Today's presenter is Jonathan Shoemaker of the law firm of from the law firm who's a member at the law firm of Lee Shoemaker. Jonathan is one of the leading defense attorneys who specialize in working with architects, engineers, and other folks in the construction industry, and is a unique individual with whom I'm sure we'll learn a lot. Design professionals are innovative problem solvers. So is today's presenter, Jonathan Shoemaker. Jonathan believes that the best solution to most problems is often the simplest. What does the contract say? Jonathan begins every new engagement uh, seeking to understand how the parties on a construction project elected to allocate risk and responsibility before the project, and then works with his client to develop a plan for bringing the issue to resolution as expeditiously as possible, consistent with the client's goals. Jonathan has tried cases before judges, juries, and arbitrators, and relishes the opportunity to advocate for his clients in court and in arbitration. He enjoys getting into the weeds of a dispute, deconstructing the issues presented throughout the discovery process, and then presenting the dispute clearly and concisely for the fact finder. His experience includes noteworthy appellate work on behalf of design professionals in the design professional industry. He's worked on the seminal case on the economic loss rule in Maryland, Buffer Beatty Infrastructure versus Rummel, Klepper and Call, and he drafted an amicus brief for that case on behalf of several industry leaders, including ACEC, AIA, ASCE, and NSPE. He frequently speaks on risk management issues, best practices for design professionals, different project delivery methods, and legal updates, both at in-house seminars for his clients and at programs put on by design professional organizations and insurance carriers. Jonathan, I'd like to thank you on behalf of Victor Insurance and myself for making yourself available and presenting to our clients. I'm now going to change this over to you so that you can go ahead with the presentation.
Sounds great. And thank you everyone for attending. Can you see the screen now?
I do, yes.
Okay, excellent. So thank you everyone for attending and for taking some time out of your day. Hopefully it's been a productive day thus far. If you have been binge watching either Tiger King or The Last Dance and interrupted your viewing pleasure for today's program, hopefully we can provide some entertainment, although perhaps not quite to that level. And you can get back to that shortly. So today's program is entitled Don't Just Flatten, Get Ahead of the Curve. And the reason for that is, of course, because we've been immersed for months now with this focus on flattening the curve. We've got to flatten the curve, got to flatten the curve. And, you know, the notion and the thrust of everything that has been presented to us, both through the news media and through the industry, is really what can we do to survive the current pandemic that we find ourselves in. The focus has really been on survival. So how do you survive the next 60 to 90 days? How do you evaluate whether or not you need to engage in wage reductions or layoffs in order to stay in business and to survive? How are the current conditions that we are faced with affecting your team, your employees, your obligations under contracts? How are opportunities like the PPP able to help support or buttress your efforts to survive as a company? In looking at all of this, the focus has really been on survival. But most of our clients didn't get into to this business just to survive, but rather the focus has always been on how do you thrive? And that's really the core of today's program, is not just looking at what can you do to survive and get past the first 60 to 90 days, but how do you get ahead of the curve so that you're not just focused on flattening the issues, but really thriving as a business. And one of the things that I'm sure all of you always immediately think about when you think about thriving as a business is risk management. And of course, I'm being facetious because most people view risk management as an opportunity to chat with their lawyer, which just looks like a cost on the bottom line. But I would submit to you, and hopefully at the end of today's presentation, you'll agree that really how you tackle risk management issues is imperative to not just surviving as a firm, but ultimately thriving. And so with today's agenda, we will be covering a variety of issues. This sort of lays out the general framework that we're going to cover. We'll begin with a review of the future marketplace. We'll then move on to understanding the difference between standard of care and scope provisions. We'll then move on to time-related provisions and how we anticipate they may be construed and interpreted in the near and distant future, given the current climate that we're in. And then finally, we're going to take a look at some of the unique and perhaps predictable claims that we anticipate forthcoming. And again, the goal of this program is to take all of that information collectively, hopefully to provide you some things you can think about and digest following the program, so that you can hopefully take away a few tidbits that will enable you not just to survive in the current environment, but to identify and implement strategies that will ultimately help you to thrive and be successful. Just to be fully adopting the notion of lawyering, we do have some exclusions and some exceptions to this agenda. We're not going to be reviewing each and every risk management provision that you should already have in your standard terms and conditions, some of which are identified here, but not all of them. We're not going to be doing a comprehensive review of all risk management resources that may be available to design professionals to manage risk. And we're also not providing legal advice related to specific projects, negotiations, and so on and so forth. But really the goal here is to give you some things to think about, digest, and hopefully implement that may ultimately help your practice in the long term. So the first issue we're going to cover is understanding the future marketplace. Getting ahead of the curve, from my perspective, begins with an understanding of the marketplace in which you're competing, so that you can evaluate the risk management strategies that are necessary for you to thrive and not just survive. So the first question we have to do is look at, what does the future hold? I'm going to be the first person to break it to you. If you believe that there's anyone out there who knows what the future holds as it relates to the design industry, the economics, future claims, and the like, with absolute certainty, they are blowing smoke at you. And what do I mean by that? Well, within the past month or so, we've seen economic prognosticators predict that there's going to be a construction tsunami in Q3 2020. Under that thesis, there's a backlog of projects that are ready to get going, and the only thing holding them up is financing and the finalization of financing. And once the financial markets recognize and have confidence that the economy is on good, strong footing, that there will be a construction tsunami in Q3 as the backlog of projects are unleashed and everyone will be fat and happy again. There are, of course, other folks who take a much more pessimistic perspective of where things stand. Um, and what do I mean by that? They're looking at a downturn in the economy. For those of you who have been tracking the Architectural Billings Index, you'll note that they recently came out with the April information, and the ABI is at the lowest that it has ever been in the history of the index. They also reported that something like 8 in 10 architectural firms have drawn upon the PPP loan opportunities. And all of these indicia in terms of there being a decreased number of new contracts coming into design firms could portend negativity in terms of future work and what the health of the future holds. So there's a lot of different inputs that some people are looking at and saying that we are heading in a negative direction. So how do you take that information and digest it? Well, we also look at the most recent recession and the impact on the industry. And we know that there was a lost generation of design professionals. We know anecdotally that during that recession, firms were the firms that survived and adapted from CAD to BIM tended to be the firms that are ongoing concerns today, but that firms that did not adapt with the times may not have survived. We also know anecdotally that there were firms that proactively and aggressively trimmed the excesses, they removed dead weight, and that there was a significant amount of competition as it related to fees. And so that's something, it's a benchmark, it's data that certainly goes into understanding the future marketplace and trying to predict not just the economics, but what does the claim environment look like. What we know from the current pandemic, and this is of course a wonderful source, is that there are a number of different industries that have been, and particular building types that have been particularly affected. We have clients who are in the office space sphere who, when the pandemic first hit, began looking and assessing what type of staff reductions or salary reductions might be necessary in order to survive this current climate that we find ourselves in. We've seen folks who specialize in restaurant design get absolutely hammered by the current situation. We've seen folks in retail see a downturn in their work loads. And all of these things suggest that these firms that are in those sort of niche industries who have seen the greatest amount of impacts may have to start looking elsewhere. I'll use another example. In the hotel industry, there are large brands who have indicated and advised some of their closest allies that they are putting all construction projects on hold. And so if you think about what the marketplace is and who you're competing against, that level of competition may change as design firms who are tied up in one industry transition into or attempt to transition into synergistic fields or synergistic areas and building types in order to fill the gaps of their time and keep their folks employed. As such, with that sort of background and data, we anticipate that there will be an increased competition with firms foraying into new market segments. It means that there may be firms who may not understand the pricing models for your segments, or you may be looking at going into new marketplaces and may not be familiar with the pricing models for those segments or the reasons therefore. And so what ends up happening is you're going to end up seeing, we anticipate, aggressive fee structures and greater flexibility in terms of what terms and conditions folks may be willing to agree to. 2 months ago, or actually probably 3 months ago, when we were looking at contracts, we saw great bargaining power for our clients who were seeking to obtain beneficial risk management terms, whether those were limitation of liability provisions and other favorable terms as part of the bargaining process. That was more commonplace than we anticipate will be the case in the months and perhaps years ahead. As your competitors are looking for additional sources of revenue, perhaps they're willing to compromise on what indemnity language they may or may not be willing to live with. And so as a consequence, we see not the possibility of not only moving on fees, but firms saying we're not going to let an uninsurable risk that seems to be a relatively modest risk get in the way of us accepting this contract. And if that's what your competitors are doing, you may feel inclined to consider what that is, what that means for you, and what you'd be willing to consider. What I would posit and what we are cautioning our clients on is to be proactive in thinking ahead as to what your own personal thresholds and breaking points might be on negotiations. It's one thing to say we might be willing to accept a slightly lower profit margin. It's one thing to say we might be willing to forego a limitation of liability provision, perhaps to a fixed number, or perhaps foregoing any type of limitation of liability provision. But it's another thing altogether if you're willing to accept a duty to defend, the uninsurable stigma that you all face on a daily basis when reviewing contracts. And so we anticipate that those folks who are going to get ahead of the curve and thrive are going to be the firms that give thought to that and identify what it is you are willing to live with as a proactive measure, rather than being reactive in the moment and being consumed by the competition and trying to land work and letting that drive what your risk profiles are. So the first specific area that we see as being important to get ahead of the curve is understanding the difference between standard of care and scope provisions. And I think that most of our clients readily are able to distinguish between standard of care and scope provisions. But I can assure you that in the claims setting, that there are lawyers who don't understand the difference between standard of care and scope of services. And there are expert witnesses who seem to relish the opportunity to muddy the distinction between the standard of care applicable to one's services and scope of services. And it's important to understand the difference because it implicates what's going to be covered by your insurance versus what perhaps may not be covered by your insurance, and what implicates an insurability concern versus what does not implicate an insurability concern. At a high level, a standard of care is that which the typical or ordinary architect or engineer will do under the same or similar circumstances. And we're going to take a look at specific language associated with that. But at its core, the standard of care looks at the level of care that will be exercised while executing a scope of services. By contrast, a scope of services varies from project to project, but describes the general functions that are going to be performed and identifies what's included within your scope versus what's excluded from your scope. And so what I would submit to you is, in your thought process and when you're looking at contracts moving forward, especially in the near term, is being cognizant of the difference between standard of care and scope provisions. And we'll talk about them in greater detail in a minute, but the crux here is standard of care should be your non-negotiable issues, whereas scope should be where you focus on your negotiations. So a standard of care provision, and I've pulled the B101 here as the sort of flagship statement on the standard of care. It states that you're going to perform the services consistent with professional skill and care ordinarily provided by members of your profession, practicing under the same or similar locality under the same or similar circumstances. And then it discusses performing those services as expeditiously as is consistent with such care for the orderly progress of the work. But so there's a few things that I want to unpack here that I think is important for you to be aware of, because we oftentimes will see owners trying to insert or modify standard of care provisions in a manner that may create insurability concerns, which tends to be the breaking point or threshold that most of our clients find is applicable to the contracts they're negotiating. The first issue is the phrase or word ordinary as it relates to the care provided. Oftentimes you may see somebody try to insert words like best or first class. And those types of terms, while you may consider yourself to be at the top echelon of the service or that you provide, it's important to remember that the standard of care that you should be contracting for is tied to the ordinary care offered by similarly licensed individuals who are qualified to provide the same types of services in the same area that you're practicing. So that's one particularly important provision or element of the standard of care clause. Next, you look at the locality. As many of you are probably aware, if you are engaged in multi-jurisdictional practice, you know that the pandemic has affected each and every jurisdiction differently. The projects that have been ongoing in some jurisdictions have been put on hold in others. Your ability to conduct remote site visits may have been a necessity in some jurisdictions, whereas in others you may have continued to provide on-site site visits when performing construction admin type services. And so what I would submit to you is the locality is a critical component of the standard of care, because what you should be judged by is how other design professionals in your locality are judged. And then the last clause is also important, that being the same or similar circumstances. And this sort of puts us squarely in the pandemic circumstances. What are the same or similar circumstances? Well, we're all faced with the same restrictions on the types of works and services that you're able to provide. And so that's going to influence what it is you are capable of doing. So the remote site visit in and of itself may have limitations greater than if you were able to do a site visit in person. But the way in which you are judged should be based upon the level of care ordinarily exercised in the same locality or similar locality under the same or similar circumstances. What are the risks, though? We've talked about the notion of an elevated standard of care, and where we typically see this happen is where there's flowery language. And when you see that and you're reviewing a contract coming up and it's top flight or first tier, while you may think that it's nice to hear that language and that your client believes that you are top flight or first tier, this may create coverage issues because you are in fact creating what's called an elevated standard of care, not the ordinary care, but you are in fact potentially elevating and creating a heightened obligation above and beyond that which would be imposed upon you at common law. we would encourage you to refrain and avoid accepting those types of provisions. The next type of risk that you will often see, that we see in the standard of care provisions, tends to be when there are warranties or guarantees. And the creative plaintiff or the creative lawyers for the owners you may be contracting with may try to slip these in a variety of manners and in different locations. But the crux of a warranty or a guarantee is that you are promising and guaranteeing an outcome. Because all designs are novel in many respects, and it's going to be based upon how it's actually installed and whether it's installed in strict accordance with the contract documents, there may be issues that where there's a warranty or a guarantee, that you guarantee the outcome that the owner is looking for. LEED is a great example, that you guarantee LEED certification. Those are things that would create a potential uninsurable risk or a potential elevation of the standard of care that you want to try to avoid. The last sort of element of the standard of care is failing to account for what I would describe as the new normal. If you've got folks at home, I don't think that there's any architect or engineer out there who would say that having 5 quarantinis a day is consistent with the applicable standard of care when performing services. But you need to be aware of what the standard of care is given the new situation or circumstances that you find yourself in. And this is managing risk presently on current projects, but also having the flexibility to be aware that in the future, we don't know whether there's going to be a second wave, whether there's going to be some relaxation on restrictions currently, but imposition of new restrictions in September, October, or November, if there's another wave of the pandemic, or not. And so we also don't know what issues are ultimately going to manifest themselves in claims. You've likely been encountering new issues on a daily basis that you've never encountered in your past practice, and trying to figure out how does the ordinary or typical architect or engineer react and respond in this situation. So being cognizant of those issues at the time of contracting is one thing, and understanding those risks, but then there's actually how do you manage those risks? And of course, the first and foremost is making sure you're not modifying the standard of care provision in your contract, and that you're in fact including a standard of care provision. But as it relates to actually executing the work, a few different thoughts that we have as to how you might manage some of those standard of care risks would be: one, consulting with industry treatises. In many jurisdictions, the Architect's Handbook of Professional Practice has been recognized as what the courts call a learned treatise that will identify some information that may inform what you should or should not be doing in certain circumstances. But I would suspect that many of you, if you've gone to look at the Architect's Handbook of Professional Practice when faced with the notion of not being able to make in-person site visits due to a pandemic, may find that it doesn't cover every last situation. And so many of you, I'm sure, have been attending continuing education programs, whether those are put on by your local AIA chapters, local ACEC chapters, local vendors who are trying to keep you apprised of developments on their products, or programs like the one that we're having today. That provides a resource for you to hear and interact with how the industry is reacting to different risks and challenges, and provides you a foundation for understanding and reacting to the new and challenging situations that you find yourself presented with. We're encouraging our clients to remain active in industry organizations, not just through webinars and continuing education, but through committee meetings, and to the extent that there are Friday evening wine downs, attending those so that you can commiserate and share your challenges with your fellow professionals and sort of gauge reactions to challenges that you may be encountering. And then, of course, the last and perhaps lowest hanging fruit is consulting with colleagues. Always cognizant, of course, of any confidentiality obligations you may have related to a project. But there's no harm in recognizing that you are in unsettled territory, in reaching out to a few colleagues at other firms and sharing sort of the situation and gauging what they think the appropriate response is. And then perhaps, not sharing it with anybody outside of the firm, but perhaps an internal memo saying, I chatted with my highly respected friends and colleagues at these other firms, and the consensus was that this was the best approach, which is why we're going to be implementing that approach. And just having that as a note in your file may help you down the road. But certainly drawing upon the thought process of your peers is always a valuable resource when faced with new and interesting challenges. So we've talked about standard of care issues. The next issue is really distinguishing that from scope of services. And we've outlined here the typical scope of services included in the AIA B101. I'm sure you're all familiar with these. We are seeing a significant amount of deviation from scope of services from project to project. The AIA in their April report related to the ABI has described the fact that they're seeing significantly reduced fees, and we can speak anecdotally from the contracts that we review, because we that the contracts that we see coming across for new projects include heavily modified scopes of services, and really heavily modified in two different directions. Sometimes the modifications are extraordinarily onerous, meaning it suggests that there are probably duties and scopes of services well above and beyond those which most of our clients typically include in their fee proposals. And then the other type of scope change that we're seeing is dramatically reduced scope, whether that's limiting or removing construction phase services in their totality, or whether that is taking on or modifying the number of the scope and extent of the different design phases. There's a variety of different ways in which we've seen owners seek to modify and trim from scopes of services in order to obtain a better or reduced fee. And so understanding that is critical for managing your risk. Some of the risks that we specifically see, they're largely related to the construction phase services, which are your last three bullet points on this slide. But we are seeing sort of issues associated with the design phase as well. The first and foremost is the notion of limitless design development meetings. When do those meetings take place? How do they take place? And how much productive design review are you accomplishing if you're having to do that remotely? It's always great, of course, to be able to have a client in your office and to be discussing the development of a design, and to be able to pull up images from other projects, or to pull out samples of a particular product that you may have sitting in your inventory, so as to be able to illustrate and make a decision in the moment and move forward productively. But sometimes, because you may not have the ability to meet in person, the remote or virtual design development meeting may not be as productive as possible and may, in fact, result in you going down one path and then a design decision being revisited and sort of setting back the design process. Most of the time, we find that owners don't appreciate the importance of making decisions at the right time during the development of the design. And so we view this risk as being a potentially significant risk in today's climate. Another risk is the review by an authority having jurisdiction. We have personal experience with this. We're actually in the process of expanding from our just one office here in Washington, D.C. to a new office in Charlottesville, Virginia. And we've seen firsthand the impact that this pandemic has had on the authority having jurisdiction in terms of reviewing and approving plans and then executing and completing inspections and approvals of the progress of construction. And we've also seen instances where there have been miscommunications with the authority having jurisdiction and their plans reviewer, where updated plans are loaded into the system, but they're not properly funneled remotely to the plans reviewers, and the plans reviewers have rejected updated plans because they were actually not looking at the updated plans, but were looking at the old plans, and then expressed frustration at the fact that the plans had not been updated. And this can have a negative effect on project delivery and the like. Similarly, what the resources are for each and every jurisdiction varies. And our experience with every type of jurisdiction is that anytime the plans reviewer gets frustrated with a plans review process, it can sometimes have unintended or unanticipated consequences in how strictly they are reviewing the plan and whether they agree that a detail meets their code requirements or whether they are looking for something that perhaps is above and beyond, but they're doing that because they are trying to enforce the letter of the law as they see fit. Other scope of service risks we see implicated frequently, and this is in the past, but we anticipate it will be especially true here in the current climate, is limitless site visits, limitless and uncontrolled submittal review, limitless and uncontrolled RFI review. You know that these are areas where you constantly are probably losing money if you're not closely defining your scope of services and then enforcing the contract requirements related to site visits, submittal reviews, and RFI reviews, and the RFI process and submittal process on a whole. But these are things that we anticipate there being risks moving forward. So how do you manage those risks? Well, use exceptions and clarifications and limitations when defining scopes or issues. You'll recall that at the outset of this program, we included some qualifications and limitations as to what we would or would not be covering. And that's because we wanted to be clear. Here's what we're doing. You can seek guidance from the client when you are defining and qualifying scope of service issues, meaning you don't have to be antagonistic. This doesn't have to be, my scope doesn't include this, and I just want more money. You can cajole and sweet talk your client and explain that you're happy to provide the scope of services that perhaps the client's lawyer has proposed, but there may be additional costs associated with that. Or you recognize that the client may not have an unlimited budget, and so you developed a scope that you felt was consistent with the client's program and budget, but that if they're looking for more, you'd be happy to provide more, but that would likely have fee ramifications. And if you describe these issues as scope issues and are able to explain what exceptions or clarifications or limitations may be included in your fee, we find that oftentimes the clients are amenable to well, yeah, I was really happy with your fee and I love working with you. So let's figure out what we can do or what the impacts might be if we were to add this back in. And so you start framing the issue as a scope of service issue by the careful use of exceptions and clarifications, and not just accepting carte blanche the scope proposed by the client. At the end of the day, you need to give thought to not just what the scope of services are, but what the total fees are going to be and what the terms and conditions are going to be. In our experience, we suspect, and this is based on anecdotal claims we've seen come in already, we anticipate that folks will be the fee structure and strategies and buildups that you have used in the past, which have been based upon obtaining a particular set of terms and conditions that may have been acceptable in the past, may be different if you're not able to continue to obtain those terms and conditions. And if you're not able to manage that risk in terms of what your impact to your day-to-day workforce might be. You know, is there additional costs or lower costs associated with having your team working remotely? All of those issues are things which we believe you ought to be thinking about when you're potentially revisiting your fee buildup so that you can be ahead of the curve and know where you need to be. But it's one thing to just talk about understanding and getting ahead of the curve on scope and fee and standard of care with your client. There's also a critical component that oftentimes we see our clients overlook, and I would submit is imperative that you consider nowadays. And that is understanding how your internal incentive structures for your team may affect the riskiness of a contract. And what do I mean by that? Well, we had a client at one point in time who developed an end-of-year bonus structure based upon the overall contract revenue delivered by the different profit centers within the organization on an annual basis. And what they ultimately found out was that some of the folks, the business guys who were driving landing work and trying to drive profit or revenue in the door and new contracts, were willing to sign contracts that might have questionable risk profiles and or might not have full and robust fees to cover the full scope of work. And so they ended up bonusing people on the one end, but that they were never really punished when the projects came in over budget or perhaps with claims on the back end. And so one of the things we are suggesting as a metric for managing that risk is understanding how you have internalized incentive structures. Who's responsible for project profitability? Are they involved in developing the fee for the project and correlating that to the scope? Who's responsible for project quality? Does the fee include an appropriate amount of time for quality management? We are used to seeing the quality program at many firms be implemented both with a seasoned hand, typically somebody off of the project team, but also through studio-style oversight by the project principal, who may ultimately be responsible for signing and sealing a set of plans. And it's one thing to sort of spend on a daily basis walking around a studio and touching base with each project team to see how designs are being developed and to kick around ideas and to catch issues as they're being developed in the moment. But now that we are in a different working environment, that is, if you don't know whether you're going to be in the studio or not, there may be different time efforts necessary to obtain the same quality. There may not be, and you may have found that it's actually more efficient to have this done remotely. But all of these things and understanding how employee performance is measured is going to may impact the overall risk profile of a project. If if your team is measured on how well they manage a project to budget, and they are at their budget, they may not be inclined to spend the time necessary to fully and completely resolve an issue if the incentive structure punishes them for that. So getting ahead of the curve requires understanding the internal incentives. The next big picture issue that we want to talk about, having talked already about standard of care versus scope, is understanding the importance of time-related provisions in future contracts. And you've probably seen a lot of focus on these particular provisions in the various news blasts and news feeds that you're on, addressing risks in today's day and age. You've seen the prospect of delay claims. You've seen the importance of this mysterious clause called a force majeure provision. And so these are all important things, but staying ahead of the curve is not just understanding what they are and what do you have in your current contract, but it's understanding how can you utilize these types of provisions to your advantage in the months and years ahead to get ahead of the curve. And so there's three different subcategories within these time-related provisions we're going to take a look at. The first is project schedule, and by that I mean not the contractor's project schedule, but the project schedule that you carry as sort of the initial information at the time you're signing your contract. Next, we're going to talk about the additional services that you may be providing, assuming that you're closely and paying attention to your scope of services. Part of that is understanding what are the additional services that may become necessary, and then looking at notice provisions and being aware and cognizant of those from a risk management perspective. So getting ahead of the curve first requires understanding the project schedule and understanding how deviations from that project schedule may impact your price and your delivery of your services. As I said, we're focusing right now on the overall project schedule, starting with the design. Under the AIA B101, the default is that at some point in time after signing this document, the architect and the owner are going to, in fact, put together some type of performance schedule, and that's going to be somehow referenced and used as a moving forward perspective. Our experience and our recommendation is to bring the schedule negotiation not to post-contracting, but ahead of contracting, so that there's agreement between owner and architect or owner and engineer as it relates to what the schedule will be and the schedule on which the fee is based. Oftentimes, a schedule or a fee is built up based upon an anticipated duration of construction from this period of time to that period of time. It's based upon an anticipated design development period from this period of time to that period of time. And having a benchmark and an understanding is critical, and oftentimes is important to have it as, in fact, a part of your contract, so you can go back and look at that particular document and say, here's what we agreed to. We are now in a changed situation. But the other thing that's critical about this is understanding sort of how that schedule implicates or how that schedule may be affected by the current conditions and climates we find ourselves in. Typically, when you're putting together a schedule, you assume 2 weeks or 3 weeks for authority having jurisdiction review. You may include a week or 2 weeks for owner review of different phases of the design development. But if those timelines are exceeded, that's going to implicate and affect the overall schedule. And that can be significantly impacted by things beyond your control, such as the pandemic. Um, the AIA B101 does not include what's called a force majeure provision. It includes a general provision that says that to the extent the architect's services are impacted for reasons beyond its control, the schedule for performance will be equitably adjusted. The A201, by contrast, and that's what I've put up here on the screen, does include a more typical, what we would refer to as a force majeure provision. And even this provision is something which in today's climate could and probably should be beefed up to specifically contemplate impacts associated with the pandemic. And whether you're managing this risk, the risk of your services being affected negatively because of the pandemic sort of rearing its ugly head in the future, or dealing with it currently, it's important to be proactive in thinking through these issues, because a court looks at a contract based upon what was known by the parties at the time that they entered into the contract. And there are a variety of risks that you know about at the time that you're entering into a new contract that may affect your project schedule. The owner, and some of those things may be impacted by the pandemic, whether it continues or doesn't continue, whether it lags or rears its ugly head again. Things that could impact you if the pandemic persists may be the timeliness and frequency of owner reviews, the phasing of design submissions, meaning when you're actually able to get it submitted to the authority having jurisdiction, whether the owner seeks to go through a phased permitting process instead of a traditional one-off permitting process. How quickly the authority having jurisdiction does in fact review a submission. What type of pre-con pricing activity takes place and when it takes place. The duration of construction may be affected. Compliance with what I call paperwork schedules, meaning are submittals submitted in accordance with a submittal schedule? Are RFIs submitted in a timely manner so as to avoid impacting the progress of the work? All of these different things are things that may be implicated by the long-term impact or non-impact of the pandemic on the performance of your services. And if you are not addressing pandemic type issues and either excluding or baking in assumptions as to what your expectations are at the time of contracting, what you're doing is you're empowering lawyers down the road to try to recreate what your expectations were because they were not articulated. So how can you manage that risk? How can you manage the risk that a court says, well, you knew that there was a pandemic, but you chose not to contract to specifically exclude pandemic-related impacts from your proposed project schedule? Well, the first thing you can do is, of course, define the project schedule ahead of contracting. And when I say define it, I don't mean just take the rudimentary schedule that you perhaps attached to your proposal, submitted months, if not years, before you actually sign the contract. I mean, look at what the actual schedule is at the time of contracting and update it so that it actually reflects reality and that there's an agreed upon point between you and your client at the time of contracting. Here's where we stand, and does it or does it not incorporate and account for the risk of the pandemic extending for an unforeseen period of time? Does the schedule that you've included, or does the language in your contract contemplate, here's how much time we have assumed as it relates to owner-related review of design development or authority having jurisdiction review? And have you included frameworks that say we agree between the owner and the architect that these are reasonable time periods based upon what we expect, but there's some uncertainty as it relates to how long the authority having jurisdiction may take to review things given the pandemic. Have you discussed with your client and documented in writing those factors which may affect the schedule that you're choosing to include in your contract? Those are important things to at least be thinking about, and I would suggest incorporate into your contract so you're not dealing with lawyers after the fact trying to figure out what the party's agreement was. Finally, the last note is, do you incorporate a broad force majeure provision? And I would suggest that perhaps the safest course of action is to include a broad force majeure provision. That is a provision that says acts of God and things that are entirely beyond the control of the parties shall entitle the design professional to additional time and potentially compensation if warranted, and to specifically identify pandemic-related issues as covered under the force majeure provision. Those are things that we have been including and have not had any real pushback on thus far in future contracts, and it's an important feature for managing that risk moving forward and being proactive. The next category we're talking about are additional services. What additional services are you asking for, are you including in your contract when you're trying to get ahead of the curve and you're managing scope, what's in versus what's out? The AIA B101, of course, includes a variety of additional service provisions, some of which are provided without any notice, and you're supposed to provide notice, and the owner will reimburse you unless and until they tell you to stop. And some additional services you're not supposed to provide until such time as you have been directed to by the owner. And so we've got the two different provisions that we've just looked at. But as a risk management perspective, we've seen a lot of owners over the years, even when times have been robust, monkeying around with the additional service provisions. And part of risk management is understanding what's in your scope versus out of your scope. We would submit to you that being aware of the risks of modifying this language is critical, and that you have the foresight to address it ahead of time. Specifically, there's language that we see routinely used by owners as a basis for withholding payment from design professionals or for refusing to agree to add services, and that is the dreaded except for services required due to the fault of the architect language. Who decides whether or not a service is necessitated by the fault of the architect? Another risk is that we see design professionals fall prey to is failing to ask for additional services. Hopefully none of you have ever had to be on the receiving end of a claim, although I suspect that many of you have. And if you have, you're aware of the fact that owners sometimes try to take the position that the fact that you didn't ask for additional compensation when you could have should be treated as some type of admission of fault, as opposed to you being a team player trying to help out the project and you having sensitivity for the fact that if the owner has been let down by someone, probably not you, and you don't feel like keeping on top of the pile by asking for additional compensation, even though you'd be entitled to it. So risks abound when you don't ask for additional services in a timely manner. Additional sort of risk issues that we see associated with additional services are differences between the prime contract, what's an additional service there, and subcontracts, what are the additional services there. So there are a variety of things that you can do to manage these risks. And those include making sure that you clearly define and preserve whatever your suspension and termination rights are. You know, the easiest thing to say to your client at the time of contracting is, do you plan on paying me for the services that I'm providing? So you never have to worry about me suspending or terminating, do you? And as long as you pay me fairly, I'll continue to work. But if you can't have that type of conversation with your client, especially in this type of environment that we find ourselves in, you need to be thinking about how effectively are you able to manage the risk of services and risks faced by your company. Also, considering what right does the owner have to withhold from you for additional services. The third bullet point is a classic one. We routinely see owners refuse to pay legitimate additional services to a designer because, by golly, the contractor says that the designer has somehow held up the project. Of course, the owner isn't paying the contractor either. So in other words, the owner is not paying anyone. They're just sitting on the money. And if the owner is not agreeing that the contractor is entitled to additional compensation, I would submit that they should be paying you for the extended duration of any impacts to the overall schedule. The last sort of time-related clause we're going to be talking about today is the notion of a notice provision. And fortunately, the AIA B101 as a flagship does not include onerous notice provisions. But I'm sure you've seen onerous notice provisions proposed by your clients from time to time. These things are provisions which say that you have a fixed time frame for providing notice. There's specific information that must be included in the notice. And there may be a waiver clause that if you don't provide notice within a specific time frame, or if you don't include all of the required information, or heaven forbid you provide it to the wrong person within your client's organization, then you have waived your right to compensation. These are things to be aware of because in uncertain times, we do recognize that there are increased claims. And so timely pursuing and availing yourself of whatever rights you have, including providing notice, is a good risk management provision or a practice. You need to understand what you're signing up for contractually. Are there hard deadlines for notices? Are those hard deadlines fair? So for example, oftentimes notice provisions require notice be provided within 10 days of the event giving rise to a change. Well, from your perspective, there may be an event that has no impact. You don't know whether it's going to have an impact on the overall project deadline. You don't believe that it should have an impact, perhaps, but the event occurs. Perhaps it's a response to an RFI. The contractor then submits a notice of a potential claim, 10 days later, and then perhaps a month or 2 months later, the contractor submits a full-blown delay claim saying that the project has been delayed by 30 days and that they're entitled to additional general conditions and that they're not going to be able to complete in accordance with the original project schedule. So what is under your contract, if you've got 10 days, what's the event giving rise to the notice requirement for you? Is it the issuance of the RFI response? Is it the issuance of the notice of a potential claim from the contractor? Is it the submission of a delay claim by the contractor? Or is it the date on which that delay claim is resolved? And depending upon what your contract says in terms of what your deadline is, there might be an argument for saying you're supposed to provide notice within 10 days of providing a response to an RFI that could potentially give rise to a claim. And how many different events have you ever been involved with on a project where you've responded to an RFI or a submittal, and all of a sudden, out of the blue, there's an unexpected claim coming your direction? You should be cognizant at the time of contracting that type of reality and whether or not the deadlines that are proposed for providing notice are in fact fair and reasonable. Do you have a waiver provision? We find that if you're able to sort of walk a client through the type of situation that I've just described, perhaps you can explain why a flat waiver of a right to pursue a claim may not be fair or reasonable, or why it should be excluded or removed from a contract. So those are things that you should be cognizant of when you're negotiating a contract. Again, negotiating these future contracts and being aware of what your risk profile is and what risks you're willing to assume versus not assume is going to be critical for getting ahead of the curve and thriving in the future economy we are coming up against. The last sort of big ticket issue and item that we're going to be talking about are the unique and sadly predictable claims that arise in uncertain financial environments. And we're going to be focusing on sort of three different broad brush categories of claims. One is the construction phase claim. Two are claims related to lenders' consents. And three are pay application review claims. The first big picture issue that we see are construction phase claims. And we've talked about it before, but at a high level, when the economy goes down or when there's economic uncertainty, contractor claims go up. Contractors are less certain about the next project that they have. They are more interested in fighting over every last dollar that they can get because they don't know if they're going to be able to roll over onto the next project and pick it up on the next project, and they want to invest their resources on future sources of profitability rather than taking up their time and their time, energy, and money spending time with their own lawyers pursuing claims. But so if you take with the premise that the economy is uncertain, so there's probability based upon history that claims are going to be going up, you should be aware that in the construction phase, these are the types of claims we are typically seeing when claims are asserted against design professionals. And we anticipate they will be pressed all the more strongly by contractors moving forward. The first is the coordination of design documents. We routinely hear contractors bemoan the lack of coordination in a set of design documents. And the typical pushback is tied to the preparation of coordination drawings by the different trades. Our experience is that the trades oftentimes want to minimize the amount of time and effort that they spend having to prepare coordination drawings, even if it's a requirement of the contract documents. And so they will frequently try to blame the design team for any issues that come about. And coordination in the amorphous sense is the lowest hanging fruit available. In today's BIM world, we oftentimes hear contractors complaining about the notion that the plans are not LOD 300. Of course, there's some level of subjectivity to the different levels of design and what they mean and how each different participant in the construction process perceives those requirements. And it may be that what you have been contracted for varies from what was represented to the contractor or subcontractor who is complaining about the coordination issues. So as a consequence, it's just something to be aware of. This is a type of claim we typically will see and anticipate seeing moving forward. We also anticipate seeing claims related to the timeliness of submittal review. I am quite confident that everyone who is attending this program has worked on a project where there was a requirement for a submittal schedule to be developed by the contractor at the outset of the project, where they simply didn't do it. I'm also quite confident that even if there was a submittal schedule developed at the beginning of the project, that many of you have encountered a project where the submittals were not submitted in accordance with the submittal schedule that had been provided. And then I'm sure you've heard complaints about the timeliness of submittal review responses by the design team after you probably have bent over backwards to prioritize submittals as they come in and based upon what the contractor tells you is important from a timing perspective. All of these types of timeliness claims we've seen contractors manipulate to give the impression that submittals are submitted and that there's a lack of timeliness in the response time, or that the response time is not meeting the contractual requirements. We anticipate these types of claims will continue. Similarly, claims related to the timeliness of RFI responses. Sometimes an RFI comes in and it's incomplete or improper, or the information is already ascertainable from the design documents and is really what we would describe as an improper or an abusive RFI. And it takes time to process the abusive RFI and therefore impacts the time it takes to respond to the legitimate RFIs. These are the types of claims we anticipate seeing related to the construction phase moving forward. The risks associated with these types of claims are how strictly you enforce the contract documents. We often hear owners bemoan design professionals who strictly enforce these requirements, saying, you haven't adhered to the submittal schedule, or your RFI doesn't comply with the requirements. The owner says, can't you help us out? Can't you help move the process forward? Don't you want to be part of the team? And they play upon your natural proclivities for being helpful. But sometimes helping out can have a negative impact. And so how do you help out? How do you document your efforts to help out? And how do you track things in a way that will be helpful to you in the event that the party you're trying to help out tries to twist things and blame you for the progress of the work? Those are things you should be thinking about when you're thinking about construction phase claims. And you can do that through proactive communication with your client and then documenting what it is that you've agreed to. The next big picture issue where we see risk and potential claims are through the signing of lenders' consents. For the engineers in attendance, some of you may have seen these on occasion more recently, but typically these are documents we see sent primarily to the architects, and they can tell you all about it. It's a document from the lender on the project, which basically says that the lender will have the right to step into the shoes of the owner in the event that the owner defaults. And this is part of the security that the lender wants, because they want the ability to complete the project, because part of that is the security that they look for providing the loan in the first instance. What we have found are that lenders, in making and submitting these lenders' consents, have gotten more and more aggressive. Not only do they want to have the right to step into the shoes of the owner, they want representations and warranties from the architect related to the adequacy and sufficiency of the documents. They want what are, in essence, warranties and obligations that may create insurability concerns. They may seek to modify the terms and conditions of the contract that you've already signed with your client. They may want to have the right to agree to or reject any ad services that you provide, thereby creating a barrier or potential impediment to your being paid for ad services. They may want to change or modify the right to use your instruments of service. They may want you to have to provide notice to the lender in the event of default by the owner. And how they define default may be inconsistent with how your contract defines default. So there's a variety of risks associated with these documents. And what we have found is that these lenders' consents are often sent to you a day or two before the closing date on the loan. And the goal in doing so and providing it to you at the last minute is to get you to sign this document without thinking about it and without recognizing and appreciating the risk associated with it, and therefore acquiesce to risks that you should not agree to. Our experience and recommendation for dealing with this type of an issue is to follow the advice of a gentleman by the name of William Wallace. You know, hold firm. They are not going to let their deal and their financing package fall through if you're willing to agree to let the lender take over the project on the same terms and conditions as you've already agreed to with the owner. And what I mean by that is you should make sure that you have the right to be paid for all amounts that you've earned, whether or not you've been paid it by the owner, and either the lender brings you current or they don't bring you current. And either the lender agrees to the terms and conditions of your contract or you shouldn't sign. And the rationale here is you need to be cognizant of the fact that there are risk issues associated with these documents. And if you're willing to live with them and forego the good terms you've hopefully negotiated as part of your contract, you are engaging in a risky type of conduct. The next issue that we'll talk about, and this is some of the lowest hanging fruit, is the risk associated with pay application review. This was covered a few weeks ago in Kent Stair's program. Some of you may have attended, but the concept here is critical to understand, and that is, what are you being asked to certify when you're reviewing a pay application? And here's the language from the G702 application for payment. But why is it important to understand what it is you're certifying? And here it's you're certifying the works in accordance with the capital C, capital D contract documents. That would be a term defined in the construction contract that you ideally have in your possession. There's reference to on-site observations that you may or may not be taking or making. What is it that you're certifying? That the work has progressed in accordance with the contract documents. So if you don't have the construction contract, your ability to make that certification may be hindered. But what are those risks? Well, in today's environment where there's greater economic uncertainty, you need to be cognizant of who might assert claims against your firm so you can be cognizant of how to manage that risk. And the first is the owner. That's probably the lowest hanging fruit. The owner has said that you have certified the work has progressed as far as it has. That's probably obvious. But what about the owner's lender? Oftentimes, the owner is going to provide your pay application to the lender on the project, and the lender may attempt to rely upon your certification of a pay app. And that lender may have gotten you to sign a lender's consent form discussing that particular practice. And so the lender may ultimately have claims that they assert against you in the long term if you are over-certifying the progress of the work. We've also seen, dating back to the 2008 recession, claims brought by sureties who have been tasked with taking over a project from a defaulting contractor, claiming that the architect over-certified the progress of the work and therefore overpaid the contractor for the progress of the work, and therefore harmed the surety when they took over the project. Whether these are legitimate claims or not is a matter that's probably going to depend upon the jurisdiction and the terms and conditions of the respective contracts between the parties. But being aware of the fact that there could be these types of claims of over-certification, certification of change orders, and failure potentially to account for owner claims such as delays, these are issues you should be aware of when you're entering into contracts, so you can make sure you insist on obtaining appropriate language in your contracts. Some ways to manage this risk, of course, would be no third-party beneficiary language. Language regarding notice requirements from the owner if they want to exercise a right of withholding. Finally, revisiting internal practices or policies regarding pay application review to make sure that those are in fact being strictly adhered to. And that begins with obtaining a copy of the construction contract. Being proactive in managing the pay application process and managing that risk both through contracting but also through good discipline amongst the ranks is going to be critical in the months and potentially years ahead we anticipate. The last issue we're going to talk about today is everyone's favorite, and that is the risk of getting paid. Here we've got Johnny Manziel looking to get paid. We view payment issues and slow or no payment issues being the something, these are the tea leaves that you have to read on every project. But you have to know, is this business as usual? Is this due to a financing issue? Or is this a harbinger of claims to come? We often find that owners begin to withhold payment from their design team when they believe that they have a claim against the design team. And if you're not tracking your AR closely and you're just assuming and hoping that the owner is just a slow pay or there's something, process glitch, you may be sticking your head in the sand. Oftentimes, if you're proactive in tracking your money, you're first of all going to know if there are issues. And if there are issues, you may have the ability to address those issues before they become bigger issues. It's also critical in today's environment where you don't know what which projects are going to go forward or which ones may end up being put on hold. Staying current on your AR in order to avoid getting behind and creating risks of having to cut salary and potentially lose key employees. So how do you manage payment risks? Well, first of all, we recommend preserving a right to suspend or terminate for non-payment. Second of all, we recommend you look at your copyright language. What do I mean by that? Well, nowadays, we are seeing more and more owners push for ownership of copyright rather than merely a license, which is the typical allocation of risk or responsibility under the AIA documents. And oftentimes, having a license is a mechanism you can use to obtain payment. And leverage the owner's right to use your work product to make sure you do get paid. Even if you are going to have to acquiesce to ownership, however, that doesn't mean you can't impose conditions either on when the transition of ownership of your work product occurs, or the conditions that may exist associated with the use of that work product. These are things that you might think about when trying to manage your risk associated with payment issues. The last thing you may want to think about are mechanics lien waivers. That is, whether you include one in your contract. And mechanics lien rights for design professionals vary from jurisdiction to jurisdiction. Whether there is a mechanics lien right may, in fact, be an open question of law in your jurisdiction. But whether or not you agree to a complete waiver in your contract is something you may want to think about on future contracts. And of course, anytime you are thinking about your fee, the fees that are owed to you, collection issues and the like, you should always remember that pursuing fee claims oftentimes invites a counterclaim. And in our experience, it's not just an equal and opposite reaction, but oftentimes the counterclaim is for 3 to 10 times the amount of your fee claim. And the goal is just to leverage a walkaway, if nothing else. So always be cognizant of pursuing a fee claim and recognizing that even if you do everything you can to manage the risk, you should be cognizant that there's a challenge moving forward associated with pursuing that claim, and that challenge may be a claim that consumes your time and energy in the long run. So with that, that brings us to the end of our program. Hopefully we've given you some things to think about so that you can proactively get ahead of the curve and not just be focused on surviving and flattening the curve, but really getting ahead of the curve and thriving in the economy and in the years and months ahead.
Thank you, Jonathan. Thank you very much for that presentation. If you can give us a couple more minutes, there's a couple of questions that I want to throw at you. If
Absolutely.
Does that work?
Absolutely. Happy to do so.
Yes. The question that came up is, should the indemnification clause be amended or tightened to deal with the pandemic? If you have any thoughts that you could share with our folks.
So at a high level, I think the standard markups that you have likely been implementing over the years are sufficient and adequate for your indemnity provision. Where I would be concerned might be if there's any indemnity language associated with delays to the project. And if the owner is insistent or your client is insistent on including delay-related language in the indemnity provision itself, it should be limited to damages caused, only to the extent limited to damages caused by the wrongful performance of professional services and not for other reasons. But as a general proposition, the removing defend and tailoring things to a negligence standard, I believe is an appropriate approach and should serve you well in the years ahead.
Great. And then the last question that I want to present to you is that relates to lender consent requests. And I think you may have addressed it, but what risk does the AE face from holding firm on lender consent requests? Will the AE likely face a claim from the lender or the contractor for delaying the project? And if so, what is the response?
So the short answer is that it depends. Under your contract, the issue, many design contracts include a language to the effect that you will consent to a conditional assignment of rights to a lender for the project. Depending upon the breadth and scope of the language in your contract, that may affect what exposure you would have for refusing to sign a lender's consent. However, absent language in the contract that requires that you sign the lender's consent, the biggest risk is that the financing on the project does not go forward. And our experience is that most lenders will agree to a reasonable lender's consent. And so as long as you are willing to sign a lender's consent that requires only that you perform the obligations to the same scope and extent required under your contract, I think you should be okay with holding firm. The worst thing that happens is that financing falls through and the owner contends that the lack of financing is your fault. But it will all depend upon the circumstances as to the legitimacy of such a claim. And in any event, if the lender is seeking to make modifications to your contract as part of the lender's consent process, it would seem to me to be a relatively thin claim to suggest that you should be required to modify your contractual obligations in order to receive the payment that you are otherwise entitled to under your contract.
Excellent. And thank you so much, Jonathan, for taking the time. I really appreciate your willingness to give back to the profession and to our clients. And with that, our presentation is at an end. If you have any further issues or questions, please feel free to share them with us. I'd like to end by making you aware of the resources that are available on our website. This is what it looks like. I hope many of you have an account and can take advantage of the numerous resources that are available to your firm. We also have a risk management blog that has been fairly active on providing commentary on ongoing issues that I encourage you to keep abreast of, to keep track of what is going on in the industry around us in these uncertain times. With that, our time is up. Thank you for your indulgence. At the end of this presentation, you will get a survey. And for those of you who would like a certificate or that we report this information to you, please respond to the survey and provide us with your AIA number. But our presentation has come to an end, and thank you all very much. Jonathan, are you there?
I'm here.
I'm trying to stop recording.